The Senate will come to order. Please stand for the prayer. Today we will pause for a moment of silent prayer and reflection, and following that moment, please remain standing for the Pledge of Allegiance. Thank you, members. Secretary will take the roll.
Senators Abler, Anderson, Bach, Benson, Bigham, Carlson, Chamberlain, Champion, Clausen, Coleman, Swazinski, Dames, Dibble, Dornick, Draheim, Duckworth, Dietzick, Eaton, Eichhorn, Eakin, Fate, Franzen, Friends, Gazelka, Goggin, Herr, Hoffman, Housley, Howe, Ingebrigtsen, Isaacson, Jasinski, Johnson, Johnson, Stewart, Kent, Kiffmeyer, Klein, Karan, Kunish, Lang, Latz, Limmer, Marty, Matthews, McEwen, Miller, Murphy, Nelson, Newman, Newton, Osmic, Pappas, Port, Pratt, Putnam, Rarick, Rest, Rosen, Rude, Senjum, Tomasoni, Torres Ray, Utke, Weber, Westrom, Uyghur, Wickland.
Pursuant to Rule 14.1, the following members intend to vote under Rule 40.7. Senators Anderson, Carlson, Champion, Coleman, Eaton, Eichhorn, Eakin, Fate, Goggin, Howe, Isaacson, Latz, Newton, Osmic, and Torres. A quorum is present. We'll begin on the agenda today with the second order of business, executive and official communications. The first communication listed was received and referred as indicated. There's no further action required. The next communication was received, listed in the agenda. Senator Gazelka.
Mr. President, I move that the notary's public be laid on the table.
On that motion, all in favor say aye. Aye. Opposed say no. Motion prevails. We'll move to the eighth order of business, introduction and first reading of Senate bills. Listed in today's introduction calendar are Senate file numbers 2530 through 2546. These Senate files are given their first reading and referred as indicated. We have one additional introduction to be read by the Secretary.
Senators Nelson, Weber, and Rest introduce Senate Resolution number 2547, a bill for an act relating to taxation.
Senate File 2547 will be given its first reading and referred to the Committee on Taxes. Next, we'll move to the ninth order of business, motions and resolutions. We have a few authors' motions listed in the agenda. We'll take these authors' motions as one motion. All those in favor say aye. Opposed say no. Motion prevails. Senate Resolution numbers 59 through 64 will be referred to the Committee on Rules and Administration. Remaining under motions and resolutions, the Secretary will read concurrent resolution number 14.
Senators Gazelka and Kent introduce Senate concurrent resolution number 14, a Senate concurrent resolution relating to adjournment of the Senate and House of Representatives until 2022.
Senator Gazelka.
Thank you, Mr. President. I move that Senate concurrent resolution number 14 be adopted.
To that motion, Senator Gazelka.
Mr. President, members, this is an agreement with the House that we reconvene next year on January 31st, 2022.
Discussion on the Gazelka motion. Seeing none, can we amend that to like February 20? On the Gazelka motion, all those in favor say aye. Opposed say no. Motion prevails. Remaining under motions and resolutions, Senator Gazelka.
Mr. President, pursuant to Rule 26, I designate the following bill be made for special orders for immediate consideration. I don't think the sheet is on your desk, but Senate File 415.
Members, the first bill up for consideration is number 39 on general order, Senate File 415. Senator Karan. Senator Karan.
Thank you, Mr. President. I'm happy to present Senate File 415 today. What this bill does is it deals with charitable bail organizations, and we've seen some interesting things occur with the adaptation or the growth of this group. What this bill does is it regulates and places limitations on operations of charitable bail organizations, and the goal is to really bring the organizations that participate in bail payments into similar regulatory environment as traditional bail bond businesses. In the bill today, Section 1, what it does is clarifies what a charitable bail organization is, which solicits donations from the public and agrees to deposit cash bail for another person. Requires that the charitable bail organizations to be federally recognized charitable organizations and must comply with provisions of this section and or of this section and a court rule regulating bail bond agents and organizations. CBOs that do not, or charitable bail organizations that do not issue surety bonds need not be licensed by the Department of Commerce. This licensure is normally determined by the courts. It prohibits sheriffs and district court administrators from accepting bail from charitable bond organizations that are not fully compliant with this section in this statute. It also authorizes court administrators the ability to impose administrative sanctions and costs on charitable bail organizations. Requires the administrator to also develop a disciplinary process for applicable charitable bail organizations. It prohibits those organizations from depositing bail for a crime or a violence or a crime that would require registration as a predatory offender, or a person who has been previously convicted of a crime of violence or is required to register as a predatory offender. There's also a reporting requirement with this as well. It requires the sheriffs and the district court administrators to collect specified information from the charitable bail organization before accepting money bail and classifies this data as public data. They must also register with the state court administrator and report specified information. The court administrator or the state court administrator is required to aggregate all this information and report it annually to the legislature. Section 2 also requires that the state court administrator create a registration application for the charitable bail organizations and specifies reporting dates. And with that, Mr. President, I also have an amendment. I'd like to move the A12 amendment to Senate File 415.
Senator Curran offers the A12 amendment. The Secretary will report the amendment.
Senator Curran moves to amend Senate File number 415 as follows, page 1, line 7, delete. This is the A12 amendment.
To the amendment, Senator Curran.
Thank you, Mr. President. What the A12 amendment does is it provides, in some of the conversations in the committee work and working with Senator Latz on this, it provides a 10-year look-back period and provides a little more definition on when a charitable bail organization can participate in issuing bond or issuing bail when it relates to a serious crime, not only a current active, but those that are within a 10-year look-back period of a previous conviction or whenever the person's full sentence is served. That's line 1 on the amendment 1.6, 1.7. 1.9 through 1.10, it already exists in line 2.1, 2.4 in the first and growth, but we're moving it around to add and provide clarity for the predatory offender registration offense, and also allows a 10-year look back in that period. Lines 1.1 to 1.14 follow Senator Latt's recommendations, ideas, and concerns to exclude domestic abuse violations and other levels of any level of sanction, so that most of the bills are felonies but don't exclude the violent nature, the immediate threat or harm to another person. Domestic abuse crimes excluded would include gross misdemeanors, and it also covers a couple of other sections of order protection violations, criminal domestic assault, references specific statute which provides those definitions, harassment, stalking crimes, domestic abuse with no contact orders. And then the last component is drafting error, which is corrected by staff.
Discussion on the A12 amendment. Seeing none, all those in favor say aye. Aye. Opposed say no. Motion prevails. The amendment is adopted. Further discussion on the bill as amended. Senator Curran.
Thank you, Mr. President. So that's what tells you what the bill does, but there's more to it to the story than what the bill really represents in the textual component. This type of entity, what we're doing is looking to put guardrails on to bring it back to its original intent and put some guardrails and to protect the public. One of the organizations that falls under these categories is the Minnesota Freedom Fund. It's an organization that's served and has done a great job at serving lower-income residents that needed assistance for bail support. Their typical bail was approximately $350 to make sure that nobody's sitting in jail unnecessary for a low-level offense. They also operated on an annual budget around between $100,000 and $200,000 a year. As a result of last year's riots and last summer, and a group of Hollywood celebrities, I think there was some elected officials, a variety of people all around the country, contributed and put $35 million into this organization with the intent to assist in bailing out those who participated in the civil unrest in the rioting that occurred last year. With this windfall comes great power, and there should be also a corresponding responsibility to wield this power wisely. This is where the organization is greatly diverted from helping low-income families and nonviolent criminals. The expansion of assisting violent criminals has put Minnesota residents at great risk and harm. One of the directors has stated that they don't really care what the crime is, they just don't want anybody in jail. It sounds great, but when it's a violent criminal who's committed many crimes, they should be in jail and or should have the ability to post bail as they would through a traditional. They're not only posting bail, they're not posting bail where conditions are appropriate, but they're posting the highest bail with no conditions. One of these cases was a violent criminal who's been convicted many times with a $350,000 cash bail. These are the things that put violent criminals back on the streets, and that's one of the components leading to the violence we've had in both of our metro areas. It's another contributing factor to the growing lawlessness in St. Paul, Minneapolis. Combine this with the favorable operating environment for lawlessness that's been created over the last 10 years, it's very dangerous for our two cherished cities, one being my hometown. When we create rules of engagement for law enforcement which doesn't protect and or allow them to do active enforcement, prosecutors aren't charging, and if they happen to charge and convict, meaningful sentences and consequences aren't imposed. It's one of those contributing factors, and so that's why we're putting some guardrails of why I believe this is a great discussion we should have on the floor. Covered one of those terrible outcomes is a family. Hans Olsen and his wife Jessica Soin, you'll have the information on your desk. They testified about a horrific experience, one of these very convicted criminals. Minnesota Freedom Fund posted a $50,000 bail for this violent offender, which allowed his immediate release and in an unprovoked manner attacked Hans. I don't know if anybody watched that testimony. They were shaken. These two are two people who believe in justice, social justice, and fairness. They never believed that the system would allow somebody so violently and create the victims and continually to victimize them over and over. And Hans was left with permanent brain damage, kept him out of work for over 5 months. Those are horrible consequences, and I think there's probably dozens of stories. I have many of them here. We could have filled up your desk with the same type of mentality of not only having no bail, but to have an organization that is releasing criminals with no consequence or no understanding of the violence that may occur by doing this and the risk it puts us in as citizens, law-abiding citizens. We have too many contributing factors threatening the safety and security of law-abiding citizens in Minnesota. This is why we need to pass this bill. We need accountability and transparency for all charitable bail organizations. I'll stand for questions, Mr. Chair.
Further discussion on Senate File
Mr. President.
415 as amended. Senator Pappas.
Thank you, Mr. President. Would Senator Curran yield?
Senator Curran will yield. Senator Pappas.
Senator Curran, as you know, when this bill was heard in the Judiciary Committee, there were a number of concerns expressed. The feeling was that it was not quite ready for prime time. None of the organizations that are possibly impacted by this bill were even present to testify or weigh in any way. Did you have any conversations with any of these so-called charitable bail organizations?
Senator Curran.
Mr. President and Senator Pappas, no, I haven't. And looking through all of the public statements from each of the directors and all those involved with the organization, specifically Minnesota Freedom Fund, it's very clear they don't have any intent or concern about the impact of releasing violent criminals without care or concern.
Senator Pappas.
Thank you, Mr. President. Senator Curran. I'm not sure that I would agree with that assessment. I have not heard personally that from any such organizations. I have another question for you. Will Senator Curran continue to yield.
He will yield. Senator Pappas.
Thank you, Mr. President. And Senator Curran, you mentioned Senator Latz, who is not on the floor with us today, and that it sounded like you had negotiated language in the A12 amendment with him. Is that accurate?
The sections in
Senator
which
Curran.
sorry, Mr. President. The section in which I referenced with Senator Latz were conversations that we did have and that we worked through. There were a couple other things that we did not include that were yet to be worked out, but we believed it was important to move those things we agreed upon forward in this amendment.
Senator Pappas.
Thank you, Mr. President. Sorry, there must be a misunderstanding because Senator Latz told me that he did not negotiate it with you. So I'm not sure who you negotiated that language with for that amendment. But that being the case, members, I just feel like these types of issues need to be worked out in committee, and these amendments need to be worked out with members of the committee, and that doesn't appear to have happened, and I would encourage a no vote.
Senator Curran.
Thank you, Mr. President. And the sections that I worked specifically with Senator Latz on was around the look-back period. He wanted a much shorter look-back period, and actually to make sure that we included, I think the other 4 categories, the statutes which were referenced that should be included that are around domestic assault and the level of violence in those crimes. That's why we included, and those recommendations did come from Senator Latz.
Further discussion on the bill as amended. Senator Limmer, followed by Senator Bigham. Senator Limmer.
Thank you, Mr. President. I've been listening carefully to the discussion regarding this bill, and there was a reference of whether or not certain people were not knowledgeable of this bill coming before the Judiciary Committee. I have assurance from the Judiciary Committee staff that there was a 3-day notice, as is according to our rules, and that anyone who would want to give comment for or against the bill had their opportunity to do so within that time allotment. There was no one wanting to speak, or we have no record of anyone wishing to speak in favor of the Minnesota Freedom Fund. Thank you, Mr. President.
Further discussion on the bill as amended. Senator Bigham, followed by Senator Franzen. Senator Bigham.
Thank you, Mr. President. I'm not a lawyer, but I've been around a lot of them, and I know, and feel free, any of the lawyers that are on the floor, to let me know if I am incorrect, but I believe that it's a constitutional issue about bail. The court sets it, but it's, according to our Constitution, it's allowed. So just for the body to know that legislation that would try to go around that or go over that would probably find itself tied up in the courts. And I think that under a constitutional challenge. And I think that is where the committee, of which I serve on the Judiciary Committee, had some issues. Members, I don't disagree that we need to regulate, charitable bail organizations. I don't disagree that we need to have a very thorough vetting of our cash bail system. The issue is, like many issues, the Judiciary Committee wouldn't take it up as a whole. They just wanted to do a piecemeal thing, and this really needs to have a very thorough vetting. This is a broad bill. I think the premise of trying to regulate the system and update it, if you will, is a very worthy discussion. And this is just a minuscule amount of what we have to deal with to reform that system. So this bill is still overly broad, and I will say that it was extremely frustrating in committee because, admittedly, there were still a lot of questions that were unresolved when this bill was in committee, and yet it got sent right to the floor, and here we are the weekend before session, when on Monday we have taxes that need to be filed, and we still don't have conformity on PPP or UI, and we still don't have budget targets. I mean, Senator Limmer can correct me if I'm wrong that he has a budget target. I don't believe he did. But here we are talking about this. And I'm not saying this doesn't have a fiscal note. I'm inquiring, I'm not going to ask anyone to yield because at this point it doesn't matter. We don't have targets. We're not going to get done on time. So I think this also has a fiscal impact that hasn't been discussed. So those are my concerns of the bill. I would love to see next year Chair Limmer actually have hearings that will deal with issues that holistically so that we can address much needed reform in this issue. Thank you.
Further discussion on the bill as amended. Senator Franzen, followed by Senator McEwen. Senator Franzen.
Thank you, Mr. President, and thank you, Senator Coran, for bringing this discussion forward. I do not serve on the judiciary. I am an attorney. I actually avoided the judiciary, knowing that these issues are so complex and understanding that it's good to have all voices at the table when it comes to making changes to our laws and our judiciary in particular, anything in that jurisdiction. I'm also not a judge, and I am very concerned about this bill and its language because there is a court system. We are in the legislative branch, there's a judicial branch, and there's an administrative branch, an executive branch. And I have a hard time when we bring bills that are attempting to act like a judge. And in this case, I have questions, but I want to start with the concept of bail for the public to also understand that in our judicial system, we have a system of bail that it's designated to secure money, collateral, to ensure that the defendant appears in court. That's why we have bail. And that bail or that cash payment, that collateral, is set by the judge depending on the crime that's being alleged, not committed, alleged, because you are innocent until proven guilty. That is the law of the land. And we are talking about, I wrote it down when Senator Coran mentioned convicted criminals and releasing criminals. Members, we're talking about alleged criminals and alleged perpetrators, but they have not been convicted unless the laws changed. And I obviously don't serve in judiciary, but maybe I didn't get the memo. But that is wrong semantics, wrong characterization of what we're talking about here. These are people who have allegedly committed a crime and are in the process of being held accountable through our court system. The bail, again, is the collateral that the judge assigns for that particular person, depending on their crime, depending on their flight risk, depending on the gravity of the crime. The amount is set, and if you can afford it, you can pay it. Go home, be with your family, potentially be with a monitor, electronic monitor, to make sure that that you're complying with all the conditions of that particular agreement. But members, when we're talking about aggravated crimes or serious crimes, it's a very broad description, and all the different sections that are in this bill, I would actually like to know more about what those crimes are, because in the system of bail that we have here, if you're rich enough to afford the bail, it doesn't matter what crime you committed. You pay the bail, and you can go home. You don't have to be incarcerated. You don't have to be in jail. You don't have to be held until your proceeding. That's the system, simply speaking, that we have today. And fundamentally, I understand what happened here in Minnesota. We all do. We all lived here and saw that we had national attention for what was happening. And yes, there was an outpour of support from the public. And yes, this organization that keeps being named, but it could be any other organization that follows the requirements and is able to assist people who cannot afford bail, pay for that bail. And maybe there is some conversation about regulating those organizations more than they already are. But members, this is, in my mind, a fundamental fairness piece where you have people who can afford bail and people who can't. So, Mr. President, can I ask Senator Coran to yield, please?
Senator Coran will yield. Senator Franzen.
Thank you, Mr. President. Senator Coran, can you give us a little bit more an idea how this would work if there is an alleged criminal who might fall into the categories that you describe in your bill, and there's a Venmo or there's a GoFundMe page set for this person. Would this bill make that illegal?
Senator Coran.
Thank you, Mr. President. Senator Franzen. It does not make those illegal, but what it does is the entire bill is designed to do the data gathering necessary and to make sure that we do keep the violent criminals, and I appreciate the utilization of the term alleged violent criminals. Almost exclusively the criminals that we're speaking of have many prior convictions, so they are convicted criminals and convicted violent criminals. And what the other piece you also highlighted is that you also described the system of bail and a variety of conditions that are appropriately set by a judge. In this case, they're issuing or they're posting bail at the highest level without conditions. So many of our most violent criminals are getting out and they have no conditions. They don't have the ankle monitor, and the safety of the society and the citizen, the law-abiding citizens, have no protection. It wouldn't prohibit those other organizations from being put in place, but it does put anybody who wants to operate in the environment of a non-charitable bail organization, and they choose not to be a regulated bail organization. It really goes to provide the data clarity that we need and the data collection we need to understand how this is working, and it does list a series of previous offenses, previous convictions where you may not be eligible for. But that doesn't prohibit them from seeking traditional bail at all. It doesn't restrict the judge from issuing traditional bail or those being able to cast or post traditional bail.
Senator Franzen.
Thank you, Mr. President. Thank you, Senator Curran. And I'll push back because when there's a new crime, it's still an alleged crime, not a committed crime. So let's use proper wording for people who are being accused of a crime who are in this bill about one crime, not the past. We never go back to the past in terms of bail, in terms of, excuse me, not of bail, but in terms of this bill, you're not talking about previous offenses. You're talking about the bail for the particular crime in that moment. So I think it's still improper to say criminals and releasing criminals and convicted criminals because there is a presumption of innocence. But I digress on that. Mr. President and Senator Curran, I think this bill is it's a good thought, a good discussion. I don't think it's ready for prime time. I have a lot of questions. I'm very concerned about it being overly broad and really making it harder for people who have no means to be able to have the same level of treatment in our judicial system and in our courts that those that have means. And when we talk about equity and disparities, and we talk about the budget, I think Senator Bigham mentioned the budget, we don't have to hold people in jail if we don't have to. And there are reasons that the judge, not the legislator, the judge decides and quantifies what that bail should be set amongst the reasonableness, amongst the previous conviction. That's all taken into account, by the way, when they set bail for the new crime, if there is a recurrent conviction or alleged crime. So members, I do think it has merit to be discussed. Not having Senator Latz here too, who is our expert on this type of issues, but we have other lawyers on this floor that can also voice their concern or maybe their support for this. I am a no vote on this bill. It seems to exacerbate the equity issues that we talk about. It seems to penalize an organization that's trying to do good deeds that got more support than they ever imagined would get, and is trying to make sure that the court system is also equitable in terms of representation and access to the freedom that they should have until proven guilty with the conditions set by a judge. So members, I urge a red vote, and I hope that members understand how sweeping this legislation would be for our communities. Thank you.
Senator Curran, followed by Senator McEwen. Senator Curran.
Thank you, Mr. President. And again, Senator Franzen, that I appreciate the clarity on the utilization of alleged. And I wish we would have had that utilized for the last 3 or 4 months. I think there was a very serious activity that occurred, which precipitated most of this, and I don't know that alleged term was used. So in most cases, we were speaking of the previous convictions. We do agree it doesn't prohibit judges from setting terms and conditions. It doesn't do anything to impede the judicial system. It just is in the organization of charitable bail organizations that put some guidelines and parameters. It really is about data gathering so we know who's posting the bail, where it's going, and also to provide safety and security that the most violent are not released without conditions. Thank you, Mr. President.
Further discussion on the bill as amended. Senator McEwen, followed by Senator Matthews. Senator McEwen.
Thank you, Mr. President. Would Senator Curran please yield for a question?
Senator Cran will yield. Senator McEwen.
Thank you, Senator Curran. My question is, Senator Curran, do you believe, I'm sorry, just a second here. Thank you. No worries. So my question is, Senator Curran, is it your intention, I'm trying to get my mind around what this bill is trying to do here. So is it your intention that someone who is accused of a violent crime in our state, you have this list of crimes of violence against people, some of the worst crimes, is it your intent that people accused of such crimes should not be allowed to post a bail to be released pending their trial?
Senator Curran.
Mr. President, this does not remove the ability to post bail. In fact, it doesn't have any imposition. What it does is it collects the data necessary so we understand how that bail organization or how that charitable bail organization is functioning, and the ability or the responsibility that comes with posting cash bail, especially in the conditions when it's a violent criminal, violence, especially violence against a person. And again, the conditions or the path that they've been on appears to be the most risk for the citizenry of the state. They're posting no condition bail. Bail, right? The judicial system's working, and it is not the intent to remove the ability to post bail and to capture bail. It's to remove it from this organization with no oversight or concern about the process and knowing who posted it and what risk it puts the citizenry at when you post no bail or no condition bail for this type of organization for somebody in one of those violent categories listed in the bill.
Senator McEwen.
Thank you, Senator Cran. Will Senator Cran yield for another question, please?
He will continue to yield. Senator
Thank
McEwen.
you. Thank you, Senator. So I guess my follow-up then is, so this bill doesn't prohibit the posting of a no conditions bail, is that correct?
Senator Curran.
Mr. President, for charitable bail organizations, for those that are listed in the risk or the violent category, it would prohibit it through a charitable bail organization. It does not prohibit the posting of bail through a traditional bail bonds.
Senator McEwen.
Thank you, Senator Curran. So what this really comes down to, I'm gonna kind of bring this back here, is that in Minnesota, under our state constitution, people, Minnesotans, who are accused of a crime, except for a capital offense, except for the most serious murder criminal offense, have a constitutional right to have a bail, a no-condition bail, named by the judge. So in each case that comes before a criminal court in Minnesota, the judge will name an amount of bail based on a variety of conditions, the seriousness of the crime, the chance that the person may not come back to appear again, all sorts of different things to consider. The judge will set a no conditions bail. What that means is that person can themselves or their family, or they can work with a bail bonds person to post that money bail. And then pending the outcome of their case, pending their trial, they will be free with no conditions to go home, to prepare their case for trial, to be with their family, to work a job, to do the things that they need to do in their life. Minnesotans who are wealthy people can post large amounts of no condition bail, and they do. The Minnesota Freedom Fund is doing God's work. I'm going to say that again. The Minnesota Freedom Fund is doing God's work, and I thank them. I worked for a public defender for the state of Minnesota public defender system, and I saw this injustice day in and day out. Most of the people going through our criminal system are poor. They and their families do not have the financial resources to post a cash bail. And let me go back just for a little lesson here for all of my colleagues. Oftentimes, so the judge constitutionally has to set a no-condition money bail amount. And then, in addition, oftentimes, a judge will also set a lower bail amount or a no bail amount with the option that a person could be out on a supervised release program with conditions. That it might include monitoring, other supervision, checking in with a probationary office, that sort of thing. Oftentimes, my clients could not afford to post even the lower bail amount. That means that poor Minnesotans are stuck in our county jails while they wait for the outcome of the trial to determine whether or not they are found guilty of what they are accused of. That can take months. That can take longer than a year. They are locked up waiting for their trial. They are only accused at that point. And I hear this talking about violent criminals, and I think everybody, of course we're concerned about safety. I'm concerned about safety too if a wealthy person who has been convicted previously of violent crimes is accused of another and then just posts their bail and goes free. I'm concerned about that too. I'm concerned about what they're going to do. But they have a constitutional right to that bail. And they post it, and then they're free pending the outcome of their trial. That is how our Constitution works. Those are our rights. So what you're doing here is you're setting up and reinforcing what we already have, which is a two-tier system. Constitutional rights and guarantees for the wealthy, and authoritarianism and jail for the poor. It's wrong. Again, the Minnesota Freedom Fund is doing God's work. They saw this injustice happening repeatedly. It happens every day in Minnesota. And they gathered people together and they said, it doesn't have to be like this. We can raise money, we can post the bail just like a wealthy person would do. So, Senator Cran, I say if you're going to go this route, you're going after the Constitution. Are you going to prohibit wealthy people also from posting a bail with no conditions? I'd like to see you try. That's unconstitutional. There's also in Minnesota a right to privacy for who posts the bail for someone. We just saw that in the Chauvin trial. Very, very large bail amount posted by an anonymous person. You think my clients at the public defender's office had that luxury? They didn't until the Minnesota Freedom Fund came along and it was able to help them. So yes, there will be instances anytime someone is accused of a crime, it is possible they could post the bail and pending the outcome of their trial, they could commit another crime. And that's horrible. It's scary. But under our system, we have a constitutional right to be able to post bail and to be free pending the outcome of our trial. What the Minnesota Freedom Fund and other organizations do is ensure that right is extended also to the poor. We know in Minnesota that our criminal system is grossly disproportionate in the way that it deals with class and race. I've seen the numbers from up in Duluth, in St. Louis County, and it's appalling. Almost all of the people going through our criminal courts qualify for the services of the public defender. In order to qualify for the services of the public defender, you have to be very, very poor. You have to be in a situation where there is no way that you could possibly afford to hire your own attorney. I think it's upwards of 90% of the people going through the court system up where I was practicing qualify for the public defender. So what this bill does is tell that small number of people accused of whatever crime, yeah, you people, you go ahead and you lean on your wealthy aunt, or you take your money from your special trust fund, or you do whatever you got to do, and you post your bail and you be free. But the rest of you poor saps that are getting help from this nonprofit, that's bad. We're going to keep you in jail, even though really that's unconstitutional. There's so much I could say about this. We need to eliminate cash bail. And in fact, there is a movement around the country to do just that. Illinois just took the leadership on that and eliminated cash bail just earlier this year. Cash bail punishes the poor, and the effect that it has is reinforcing the racism and the classism in our criminal systems. This bill, far from addressing the problems with cash bail, actually exacerbates it and makes it worse and tries to take a swipe at the people who are trying to make things better. So my colleagues, I implore you to think deeply about both our constitutional rights, how they are applied to different people within our communities. And I know all of you, and I hope all of you, treasure the notion of fairness within our system. Please vote for fairness. Don't vote out of fear of criminals. Because the effect of this bill is unfairness. So I ask for a no vote on this bill. Thank you.
Senator Curran, followed by Senator Matthews. Senator Curran.
Thank you, Mr. President, and thank you, Senator. I appreciate the statement of doing God's work. I think everything we propose continues to make sure that the good work they do for those that can least afford it, that's taken care of. I think Hans Olsen would differ about God's work when he was violently attacked. And that is one outcome. That's the area we're looking at, making sure the most violent have the most stringent and thorough vetting, and make sure that they all have the opportunity to post bail. And you're correct. I appreciate the lesson on bail and what the judicial system has. It doesn't change any of that. This doesn't challenge the constitutionality of it. But I think Hans Olsen would have a very different story, and all of the others who have been victims of other violent crimes when they could have been prohibited, or at least those charitable bail organizations that want to function as full-fledged bail organizations, then they should and become highly regulated. This is a niche that if it come out of clear air in other parts, as it did, our Department of Commerce and our Attorney General will be going after this organization. And so what this does is make sure that the resources are available, doesn't challenge the constitutionality, and it preserves and makes sure to protect citizens. It gathers the data and makes sure that alleged criminals, are not let free without supervision.
Further discussion on Senate File 415 as amended. Senator Matthews, followed by Senator Limmer. Senator Matthews.
Thank you, Mr. President, and I appreciate the invigorating discussion that we've had here on this bill. And some of the arguments that have been made actually still have nothing to do with what the underlying bill is intending to do. Members need to be clear. Traditional bail bonds are still allowed for any current alleged offense. Family and friends can still post cash bail, and they are free to raise those funds in whatever means they wish. The goal of this bill is that there needs to be some sunlight, there needs to be some disclosure, and there needs to be some accountability on organizations running as a business model that are going around and posting bail for people. The concept of bail is that people have some skin in the game to hold themselves accountable for making sure they appear at their required court appearances. And the courts have set levels. They may say if you want some conditions included, you'll have a lower level here. If you want to have a little more skin in the game, we can let you released with fewer or no conditions. As has been correctly said, that is the right of the court. But we heard here today that this group, the Minnesota Freedom Fund, is doing God's work. Those are words that I'd never thought I'd heard say here. You know, what is in God's work is laid out in Proverbs that tells us, a man of great wrath will pay the penalty, for if you deliver him, you'll only have to do it again. And we found that multiple times with this particular organization that's shown a light on how this can be exploited in a harmful way to families and communities around the state of Minnesota. In fact, our local media started noticing it last year. There's a Fox 9 article on August 9th, 2020. A Minnesota nonprofit with $35 million bails out those accused of violent crimes. Goes down the article, and it has a paragraph discussing who's getting out. Among those bailed out by the Minnesota Freedom Fund is a suspect who shot at police, a woman accused of killing a friend, a twice convicted sex offender, according to court records reviewed by Fox 9 investigators. Went on to give more descriptions about the systems that they found out. And it listed the director who said, I don't even look at a charge when I bail someone out. I will see it after I pay the bill because that is not the point. The point is the system we are fighting. And about 2 or 3 times in this article, it talked about how he's fighting the system. This is the same system, by the way, that just had a trial for multiple weeks for this police officer and found him guilty on all 3 counts after examining the facts and examining the evidence and applying it and coming to a decision as to what should happen for that particular case. January 28th, 2021, county attorney calls out Minnesota Freedom Fund, who charges a man that was bailed out twice. According to a release from County Attorney Freeman's office, the Minnesota Freedom Fund had posted a $5,000 and $60,000 bail for this particular individual in 2 previous cases. Members, this is here to shed some light on a system that was being exploited and used to let violent people get back out in the streets with no accountability, no skin in the game, and in some terrible, drastic cases, caused more crimes and caused more harm on our community. If that's God's work, that's not the God of the Bible. Now, we do need to stand up for the people of all levels, no matter whether they are rich or poor around the state of Minnesota, and this bill is not touching any of that. As we stated, all these different methods will be free and available to use freely as before, but there needs to be some light on these business-style organizations that can come in, free someone from having any skin in the game, and even when they have previously committed violent offenses for which they were convicted of, they just swooped in and put these people back out on the streets to do it again in our communities. That's not good for anyone, no matter what side of the aisle you're on. I won't help make an excuse for that to continue. That's why I'm going to support this bill, Mr. President, and I hope everyone joins me in doing the same. Thank you.
Members, we have several conference committees meeting today, including 3 that are beginning at 1 p.m., so we're going to get them excused. Pursuant to Rule 12.5, Senator Nelson moves that the following members be excused for a conference committee on House File 991 at 1 p.m. Senators Nelson, Weber, Miller, Bach, and Rest. On that motion, all in favor say aye. Opposed say no. Motion prevails. Pursuant to Rule 12.5, Senator Chamberlain moves that the following members be excused for a conference committee on House File 1065 at 1 p.m. Senators Chamberlain, Eichhorn, Duckworth, Dornick, and Uyghur. On that motion, all in favor say aye. Opposed say no. Motion prevails. And pursuant to Rule 12.5, Senator Newman moves that the following members be excused for a conference committee on House File 1684 at 1 o'clock p.m. Senators Newman, Jasinski, Howe, Osmic, and Bigham. On that motion, all in favor say aye. Opposed say no. Motion prevails. Back to the bill as amended. Senator Limmer has passed, so we have Senator Franzen followed by Senator Klein. Senator Franzen.
Thank you, Mr. President. And I don't disagree to have accountability. I've heard that a lot right now in the last few minutes of being pro-accountability. And I wish my colleagues on the other side of the aisle were also so adamantly pro-accountability when we talk about public safety. So with that, I do want to make a point or further expand on the point made by my colleague, Senator McEwen, when she talks about the indigent and the poor. I actually also worked in the public defenders in Hennepin County as a law clerk in my law school years, and I did see a lot of poverty. I did see a lot of recidivism in the cycle of poverty and what that means to our communities, especially our communities of color. So if we really want to fix the system, we got to dig deeper, not at the point of a crime being committed. So there's a lot of things we could be doing right now today. All the conference committees that are meeting, we should be working on a budget that actually helps lower the incidence of people being trapped in the cycle of recidivism. Mental health, I've heard that over again. People who need mental health or help or are violent. We have a mental health epidemic in our country, in our state. But we're right now trying to slash the Health and Human Services budget because we're getting federal funds. But that's not going to fix the mental health issues that we see down the pipeline. I got an offer to work at the Public Defender's Office as a lawyer when I graduated. And I decided not to take that offer because I kept seeing the cycle of recidivism, seeing the same issues over and over again. And I wanted to be the chief public defender who came to the Capitol to support those systems and get rid of them, because we can do that. And it's not with this bill. It's not after the fact when families are torn apart. And when I mean families, members, think about someone who is an alleged perpetrator of a violent crime or any crime. But in this case, we're talking about violent crimes under the list that this bill seems to focus so intently on. These people might be parents, might have jobs, are brothers and sisters. The longer they're away from those jobs and those families, the bigger the problem we're going to have to fix. And this bill does nothing to do that. Remember, don't get yourself there. You're fixing an issue of keeping violent criminals off the street with this bill. Because it's not. If you really want to do that, then let's put a budget together that deals with the fundamental baseline issue of mental health parity, of closing the education gap, of having more equitable opportunities for sustainable, livable wage jobs. That's how you fix this issue, not with this bill. And then when that father or mother ends up maybe incarcerated, stuck in jail for a few days to wait their trial, maybe a few weeks, maybe a few months, they've lost their job, they weren't there to pick up their child from the bus. That's what you're doing. You're making this issue worse. Can't you see that? And if you want this for your next re-election, well, this is not going. You're going to have more problems to solve after being re-elected, because we can solve them today. We can solve them by going to conference committee, by working on these issues, by setting targets to deal with these issues. And that is why I think today is a lost opportunity, a last day in the legislative session, just under 100 hours from last night when they were discussing another issue on the body. We're really close to being done with session, and we don't have targets. And we're here in the Senate chamber talking about this bill that does nothing to solve any issues in our state. I think that is really unfortunate, and it makes me angry, because I came here to work. not to warm up a seat. And I feel that's what we're doing. We're warming up these seats instead of doing the work that we need to do. Because if you really want to deal with these issues, don't send mom and dad to jail, well, because they can't afford it, and make the issue graver for their families. Let's fix the issues. Let's get some targets, let's get some budgets done, and deal with the mental health epidemic that we have. But let's not further criminalize the poor, the indigent, and those who are suffering. Thank you.
Further discussion on the bill as amended. Senator Klein.
Thank you, Mr. President. Just two very brief comments. I know that frequently here on the Senate floor, we have background conversations as we're trying to do work, and especially as the session ending nears, and I understand that. However, during the time when Senator McEwen was speaking, it was quite audible from my seat that there were several editorial comments, some of which were undignified. There were several other outbursts. I simply ask that you would enforce the standards of decorum and mutual respect that we've come to expect in this chamber. And I also wanted to briefly respond to Senator Matthews, who quoted the Old Testament, I believe, in talking about wrath and the foolhardiness of forgiveness in the face of a person who was recidivistic, said that the Freedom Fund was not doing God's work. You know, I don't know if the Freedom Fund is doing God's work. I don't know God's will, but I do read the Bible, and a couple quotes come to my mind. Matthew in 5:7 on the Sermon on the Mount, he said, "Blessed are the merciful, for they will obtain mercy." In Matthew 18:21, Peter asked Jesus, "Lord, how many times shall I forgive my brother? Up to 7 times?" And Jesus said unto him, "Not 7 times, I tell you, but 70 times 7. Freedom Fund is following those types of admonitions, it would seem to me. I don't know if it's God's will, but a simple reading of the Bible would suggest it might be. Thank you, Mr. President.
Secretary will give the bill its third reading.
Senate File 415, a bill for an act relating to public safety.
Third reading. Final discussion on the bill. Senator Curran.
Thank you, Mr. President. And I think we need to make sure to focus on what this bill doesn't do. It doesn't affect anybody's constitutional rights. It makes sure to collect the data and provide the safety and security and some of the guardrails to make sure the most violent, those violent accused and those previously convicted. And what we have to do is really make sure that we're here the voice of the victim. There are multiple people who have been savagely beaten as a result of the lack of and concern about how and who they post bail for. And that's what this bill does. It's a really good bill to put some guardrails on it and make sure to give us the clarity and protection and doesn't take away anybody's constitutional rights. And with that, Mr. President, I urge a green vote.
Members, we're on final passage of Senate File 415. Seeing no further discussion, the Secretary will take the roll. All members in alternate locations, please come to chamber to vote. I'll call on Senator Frentz to report the votes of the members voting under Rule 40.7. Senator Frentz.
Thank you, Mr. President. Senator Carlson votes no.
Carlson votes no. Senator Friends.
Senator Champion votes no.
Champion votes no. Senator Friends.
Senator Eaton votes no.
Eaton votes no. Senator Friends.
Senator Eakin votes no.
Eakin votes no. Senator Friends.
Senator Fateh votes no.
Fateh votes no. Senator Friends.
Senator Isaacson votes no.
Isaacson votes no. Senator Friends.
Senator Latz votes no.
Latz votes no. Senator Friends.
Senator Newton votes no.
Newton votes no. Senator Friends.
Senator Torres Ray votes no.
Torres Ray votes no. Senator Rude.
Mr. President, Anderson votes aye.
Anderson votes aye. Senator Rude.
Coleman votes aye.
Coleman votes aye. Senator Rude.
Eichhorn votes aye.
Eichhorn votes aye. Senator Rude.
Goggin votes aye.
Goggin votes aye. Senator Rude.
Howe votes aye.
Howe votes aye. Senator Rude.
Osmic votes aye.
Osmic votes aye. Senator Rude.
Senjum votes aye.
Senjum votes aye. Senator Rude.
Lang votes aye.
Lang votes aye. Senator Rude.
Weber votes aye.
Weber votes aye. Senator Rude.
Bach votes aye.
Bach votes aye. Senator Rude.
Newman votes aye.
Newman votes aye. Senator Rude.
Jasinski votes aye.
Jasinski votes aye. Senator Rude.
Chamberlain votes aye.
Chamberlain votes aye. Senator Rude. Senator Rude.
Mr. President, Ingebretson votes aye.
Ingebretson votes aye. Senator Rude.
Abler votes aye.
Abler votes aye. Senator Rude.
Nelson votes aye.
Nelson votes aye. All members having voted who have the desire to vote, the Secretary will close the roll. There being 36 ayes and 30 nays, the bill is passed as title agreed to. The next bill up for consideration is number 105 on general orders, Senate File 1589, Senator Benson.
Thank you, Mr. President. Senate File 1589 continues our learning from COVID. COVID has brought changes to our lives in ways that we couldn't imagine. And one of those ways, most people had no idea that contact tracing even existed. Now we have digital contact tracing, and governments are starting to talk about vaccine passports, showing evidence that you've been vaccinated in order to access government and services. Contact tracing is important to limit our spread of infectious disease. And it is the position of this bill that that contact tracing, while important, should be voluntary. Now that digital contact tracing has become one of the tools in our contact tracing tool belt, the bill before you says that it should be an opt-in and require your consent. Digital contact tracing apps that use Bluetooth proximity technology can inform you if you're near someone who has tested positive. But you should always have the right to limit how much information you share. For example, under traditional contact tracing, when you're asked by a public health employee where you've been and who you've had contact with, you can choose to disclose that information. Under a digital format, you may not have that choice in the future. So we want to make sure that you are always allowed to control your personal information. There's been growing controversy and conversation about vaccine passports. States like New York are moving forward in issuing them at a state level. They would require medical disclosure as it relates to your COVID vaccine. There have also been discussions of businesses limiting access based on vaccine status. I believe it is our responsibility first to limit government. The bill before you prohibits vaccine passports being created or required by our state or local government. That is our purview. It is our decision about how citizens interact with their government, and medical status shouldn't be a limiting factor as to how you interact with your government. Let me say that again. Our government should not discriminate against individuals because of their health status, nor should it put pressure to require a medical intervention. What is not in this bill language is limitations on how businesses interact with their customers, and I think that will be part of our debate today. How much should we regulate business? Can we compel the behavior of a private business? Should we limit a business if they're trying to keep their employees safe from an infectious disease? These are questions that our body would wrestle with and the public will wrestle with. If we prohibit businesses from controlling who comes into their accommodation, are we also going to limit their liability? As executive orders wind down, businesses are going to face questions about how they interact with customers and employees post-pandemic. On the other side of this debate, as businesses consider vaccine passport or some sort of medical status disclosure, they need to wrestle with the following questions. What if someone who seeks to be your customer received a single dose of the vaccine and had a serious health response and now can't get a second dose? Are they considered fully vaccinated? What if someone contracted COVID, had a strong immune response, and carries that native immunity? Will that be good enough for them to be your customer? That works for chickenpox, for our preschools and our elementary schools. Would it be good enough for those businesses who are contemplating vaccine passports? Nothing in this bill prohibits an individual Minnesotan from voluntarily sharing your medical information. That is your data. That is your information, and it is your right to decide who has it and for what purpose. This bill has taken an approach that limits government. I believe that is our responsibility, and I hope through the course of our debate today, I can gain your support that we can take some important privacy lessons from our continuing COVID response. And with that, members, I would like to offer the A50.
Senator Benson offers the A50 amendment. The Secretary will report the amendment.
Senator Benson moves to amend Senate File Number 1589 as follows. Page 2 deletes Subdivision 3. This is the A50 amendment.
To the amendment, Senator Benson.
Mr. President, these were amendments that we thought we had made in the Civil Law Committee. They did not appear in this engrossment, and so we are making a correction. On page 2, we delete Subdivision 3. This was of serious concern to the Department of Health, and it was my intention to delete this section in Civil Law. This provision would have prohibited them, for example, for tracing hepatitis impacts or tuberculosis impacts. And if we're going to limit MDH's data, this is not the way that we are going to do it, and we won't do it today. On page 3, line 27, delete the University of Minnesota. Our schools are already managed under another section of statutes. And then on page 4, delete section 3, that had to do with employers and employees interacting in digital contact tracing, and that is not the debate today.
Discussion on the A50 amendment. Senator Matthews.
Thank you, Mr. President. I just want to confirm this amendment does reflect the will of the committee a few days ago, and I urge members to adopt the A50 amendment.
Any further discussion on the amendment? Seeing none, all those in favor say aye. Aye. Opposed say no. Motion prevails. The amendment is adopted. Further discussion on Senate File 1589 as amended. Senator Westrom.
Mr. President, I rise in support of the Benson bill. Very unfortunate we even have to have ourselves in this position of defending our constitutional freedoms, rights to privacy, but we do. And at a minimum, government should not be the offender of the fundamental rights enshrined in our state and our national constitution. And so I rise in support of the Benson bill and urge your support. Members, I'd also offer the A7 amendment.
Senator Westrom offers the A7 amendment. The Secretary will report the amendment.
Senator Westrom moves to amend Senate File number 1589 as follows, page 4 after line 14. Insert, this is the A7 amendment.
To the amendment, Senator Westrom.
Members, this is an attempt to discuss an issue that isn't in this bill, take a good bill and make it better. But members, what this amendment would do would extend the same right of privacy to individuals of their health records, whether they've been vaccinated, whether they've had diagnosis or tests positive or negative, and extend it to places of public accommodation. So businesses that are frequented by the public, allow the public in as a way to preserve the fundamental rights of privacy under our Constitution that our country has as a fundamental principle of life, liberty, and property. And members, this would, though, respect businesses that have had a reason in the past to ask or request for medical information. So if they've done this as a course of business over the years and decades, for whatever reason, there might be a few. This recognizes that if they've identified or asked for that vaccination or those private medical records before, prior to March of 2020, pre-COVID, they would be able to continue as they had before COVID-19 hit this state and country. And so, Mr. President, members, I look forward to discussion and ways we can try to make this bill even a little better, or recognize the issues that are in front of our citizens across the state of Minnesota of legitimate concern. And members, you might say, why do we even need this bill? Why do we need this amendment? Members, we are joining 40 other states, or 39 other states, who are discussing and advancing restrictions on a vaccine passport. Contrast that with New York and the New York governor, who has championed what they call the Excelsior Pass, seemingly maybe a more acceptable name than a vaccine passport, but it's the same thing. Using taxpayer money in the state of New York to adopt a digital passport for people to enter businesses, to go to sporting events, or to go to gatherings, use public transportation, and other means as a way to separate or invade privacy medical records. And that is going on right now in this country, in the state of New York. Other states are contemplating it. Recent article I read, 17 other states are looking at advancing this type of vaccine passport idea in order to travel, in order to enter businesses or government places. And so that's why this is such a critical, fundamental rights issue of life and liberty that we find ourselves in. And so, members, I think this is fairly common sense. It very much aligns with our Constitution and the principles our founding fathers and all of us have supported of keeping medical records private information for individuals, not for government, not for others in the public to know. And so this amendment would do just that and take a good bill and make it better.
Further discussion on the A7 amendment. Senator Klein, followed by Senator Wickland. Senator Klein.
Thank you, Mr. President. And I'm grateful for the discussion around the amendment, the A50. And members, I'm going to encourage a no vote on the A50. It addresses a problem that does not exist, which is this concept that private businesses would require vaccine passports to enter their facility. It creates a stigma around vaccination and around proof of vaccination that's unnecessary. It doesn't get to the core problem, which I'll address later after third reading, that we face with conquering a pandemic in this state. So I will be voting red.
Members, just so we're clear, we're on the A7 amendment, but I think Senator Klein's comments were to the A7. Senator Wickland, followed by Senator Pratt. Senator Wickland.
Thank you, Mr. President. Yes, I would rise also in opposition to the A7 amendment. I believe that, as Senator Benson stated in her opening comments, that there is a lot of discussion going on about how we go forward with people feeling comfortable going back to businesses, going back to events, going back to event spaces. And there is a lot of discussion about whether part of that comfort will come from knowing that all those who are within the space are vaccinated or not. I think businesses across the country are wrestling with this question. And I think that in order to really understand all of the concerns and the issues that need to be discussed in this case, we need to have the input from those entities that would be affected by this amendment. And that has not happened. It didn't happen in the Health and Human Services Committee. We did not have business input on an amendment like this, and that input did not occur in the Civil Law Committee either. Businesses did not come and testify about whether they would be supportive of an amendment that would limit their ability to inquire about vaccination status. And so even though the amendment states that if businesses already have a provision in place that ask about vaccination status, I just don't think that is helpful in this case, and we shouldn't be moving forward with anything as complex as this without having a lengthy discussion in committee with the appropriate stakeholders coming to us to talk about what their concerns are. And we need to do that at a minimum before we move forward with anything like this. Thank you.
Further discussion on the A7 amendment. Senator Pratt.
Thank you, Mr. President. I want to rise in support of the A7 amendment. We've just gone through a really interesting year in how we walk about in our community. And with the notion that the CDC yesterday lifted the mask mandate, and presumably the governor is going to be signing an executive order lifting the mask mandate in public, I think it's interesting for us to think about this. We're not saying no masks. And if I go to a convenience store, if I go to a grocery store, if I go to a clothing store and they have no shoes, no shirt, no service, I abide by that. If they want me to wear a mask to protect their employees, I'm willing to do it. What I'm not willing to do is hand over a vaccination record that discloses my personal health decisions to say that I need to do business, I can do business there. I appreciate Senator Westrom limiting this to places of public accommodation. And we've had that concept in law for a long, long time. No business should know whether I've been vaccinated for chickenpox or polio or COVID-19. If they want me to wear a mask and if I want to do business there, I'll wear a mask. just like I wear a shirt and shoes. But, members, we should not allow anyone to dive in to our personal health records, and I encourage a yes vote.
All right, members, we're on the A7 amendment. All those in favor say aye. Aye. Opposed, say no. No. The motion does not prevail. The amendment is not adopted. Further discussion on Senate File 1589 as amended. The Secretary will give the bill its third reading.
Senate File Number 1589, a bill for an act relating to health.
Third reading. Final discussion on the bill. Senator Klein.
Well, thank you, Mr. President. And I listened closely to Senator Benson as she presented the bill, specifically to see what was the problem that we're solving today on the floor. What is the crisis in Minnesota surrounding vaccination records and contact tracing, and who are the individuals who have come forward saying that their privacy has been abrupted? Where are the complaints from citizens in our email inboxes saying that they have been violated? I unfortunately didn't hear any of that in the presentation of the bill. What I'm surprised at is, imagine looking back on this day that the mask mandate is lifted in our state, looking back on the 500,000 Americans that have died over the last year from this illness, and trying to distill the lessons that this devastated landscape has taught us. You know, compare our experience to countries like South Korea and New Zealand, who effectively mobilized very early contact tracing, brought their death counts close to zero. Imagine looking at that and concluding that what Minnesota needs now is more restrictions on contact tracing. Imagine taking off our masks in this chamber for the first time in months because immunizations have been developed so effectively and quickly and implemented so well, and concluding that what Minnesota needs now is restrictions on immunization information. You know, it'd be like if we met after Victory Day in World War II and decided what we need to do is dismantle radar systems in Hawaiian harbors. Here in Minnesota, our most successful responses to the pandemic have been from institutions which were nimble and aggressive in mobilizing technology and staff to perform contact tracing. At Mayo Clinic, a system was developed within 2 weeks of the first COVID-19 case. It utilized electronic tools to identify healthcare workers exposed to a patient with COVID-19 and prevent spread to patients or colleagues. It operated day and night. It integrated medical record data with non-clinical information and contact tracing resources to shut down viral spread on their campuses and maintain a safe setting for employees and staff. This bill would stifle that kind of innovation. And we still don't know what problem we're trying to solve. Has MDH data on COVID cases been compromised and exploited? Have contact tracing mandates been proposed by any legislature or governor across the United States? Why, at this point in time, would we restrict and constrain the work of our public health staff at the Department of Health after their heroic year of laboring to save our lives? It's worth remembering, as was pointed out, that MDH has been doing this work, contact tracing, quietly and without fanfare for years before this pandemic. The state has been conducting contact tracing for sexually transmitted diseases for nearly 100 years. It has never proposed mandates for that hugely successful work. It has never needed them. MDH provides tennyson warnings to all contacts, informing them of their tracing data and use as required by law. Section 2 of the bill, which prohibits state-run facilities from obtaining immunization status on their employees, will have real consequences on the safety of our state hospitals and correctional institutions. It will impair the capacity of our state to protect both clients and staff at those facilities. It would prohibit, for example, the Hennepin County Jail from requiring a guard to document their vaccination status. Well, now that individual, that guard, their personal decision has far-reaching implications for the safe operations of that entire facility, and the employer has a legitimate interest in documenting safe vaccination rates. I believe the Senate File 1589 is ill-conceived, it's poorly timed, it's unnecessary, it is an attack on public health and contact tracing at a time when those tools are demonstrably more necessary than ever. It raises unfounded concerns about state mandates and privacy violations which have no basis in experience, and I urge a no vote.
Final discussion on the bill. Senator
Thank you, Mr. President. I also rise in opposition to this bill. I won't reiterate the specific examples that Senator Klein has given, but I will say that in summary, I believe that contact tracing is being done today in an effective and respectful manner that does respect personal privacy. It is not mandatory today, and there are parameters in place to protect individual rights. And because it is such an important public health tool, it should be allowed to continue as it is today. We need to maintain the current processes, and this contact tracing is a core public health tool and needs to be available as we move forward for the many communicable diseases that it is used for. In Section 2, I think that the bill will serve to create confusion. It has language that says that, except as otherwise provided by law, that there are cases, it seems to acknowledge that there are cases where requiring the proof of immunization or knowing a testing status or requiring testing is allowed, but it is very difficult to parse out exactly what those situations are in comparison with the blanket statements in this bill that local governments and public health will be covered and restricted. There are situations where knowing the testing status of an individual is going to be required. Requiring immunization is going to be needed, and requiring testing is going to be needed. People are, in certain situations, going to need to be required to provide the information. And considering this bill did not have any input or discussion by local government entities and public health organizations as to what the impact would be on them if this was put into law, we really need to have that discussion before we can state that this bill will serve a positive purpose. I think that the bill overall will serve a negative purpose. It doesn't meet the needs of what we've already seen needed over the past year. And I think in addition, we could be spending that time discussing this bill. We could have been spending on working on the issues that Minnesotans expect us to be discussing and working on today, only a few days before session ends, relating to budgets, relating to public safety and taxes. And this time is not well spent discussing this bill here today. Thank you.
Any final discussion on the bill? Senator Uyghur.
Thank you, Mr. President. Would Senator Benson please yield?
Senator Benson will yield. Senator Uyghur.
Thank you, Mr. President. Senator Benson, I was in E12 Conference Committee. I didn't hear the initial part of the presentation, but a question. Would your bill restrict the ability to require vaccinations for the Minnesota National Guard?
Senator Benson.
Mr. President, the National Guard already has a vaccination policy that's in place. This relates to the state not setting up a passport requirement.
Senator Uyghur.
Okay. Mr. President, Senator Benson, just to clarify, continuing to yield, so this bill does not apply to the Minnesota National Guard in the context of the reference to state agencies, et cetera?
Senator Benson will yield. Senator Benson.
Mr. President, it's my understanding that members of the military and Guard are presented with necessary vaccination depending on their mission. I don't know that COVID under emergency use is mandated for the National Guard, but I know that it is offered, and they are high priority. So I don't have the information before me.
Senator Uyghur.
Okay, Mr. President, it's my understanding that it's optional now in looking at the website for the Guard, and perhaps Senator Duckworth would know the most about this subject. but it's my understanding that once the vaccine has full FDA licensure, then it could be required, and that hasn't been decided. So my concern was whether this bill could potentially conflict with the ability to have this as a requirement. And it's my understanding that the author is saying it would not.
Mr. President, that would fall under the, as otherwise required by law. The National Guard has a whole bunch of special rules that apply to them that don't apply to regular state employees or regular citizens.
Okay, thank you, Mr. President. Just for the record, this would not apply to the Minnesota National Guard. Thank you.
Members, any final discussion on the bill? Senator Benson.
Thank you, Mr. President, and Senator Klein and Senator Wickland for your well-raised points. Contact tracing has been important. That's why I started with contact tracing is important as part of our public health response. But this bill is about privacy, which nobody worries about until it's over. This is about the rights of citizens to engage with their government until nobody worries about until it's over or until the action has been taken. This is to look forward. This is not to condemn things that have been done in the past. In particular, digital contact tracing. 2 years ago, did we have Bluetooth devices that could be loaded on our phone and share our information? Now, right now, those are all opt-in, fully informed consent. But they are a developing tool, and there is technology developing that would make it just part of the app that your data got shared. I want to make sure that we are clear as technology is being developed that the individual's right to control their information remains an important part of deciding technology development, contact tracing or otherwise, but this field deals with contact tracing. Should governments be able to restrict your access based on your COVID vaccination status? That's the question before us. I tried to take a limited approach so that the rights of individuals to keep their vaccination status remained with them and couldn't be compelled by government. So it's my hope that I have looked forward, not backwards, and learned lessons from individual rights that have been lost over time in other circumstances and had to be fought back. In Minnesota, we take privacy and medical rights very seriously, and I'm trying to stay in that tradition with this bill. I hope that I have struck a sweet spot, and I would appreciate a yes vote.
Members, we're on final passage of Senate File 1589. Seeing no further discussion, the Secretary will take the roll. All members in alternate locations, please come to the chamber to vote. I'll call on Senator Thomasoni to report the votes of the members voting under Rule 40.7. Senator Thomasoni.
Mr. President, Senator Bach votes no.
Bach votes no. Senator Jasinski.
Thank you, Mr. President. Senator Anderson votes aye.
Anderson votes aye. Senator Jasinski.
Senator Coleman votes aye.
Coleman votes aye. Senator Jasinski.
Senator Eichhorn votes aye.
Eichhorn votes aye. Senator Jasinski.
Senator Goggin votes aye.
Goggin votes aye. Senator Jasinski.
Senator Howe votes aye.
Howe votes aye. Senator Jasinski.
Senator Osmick votes aye.
Osmick votes aye. Senator Jasinski.
Senator Senjum votes aye.
Senjum votes aye. Senator Jasinski.
Senator Lang votes aye.
Lang votes aye. Senator Jasinski.
Senator Abler votes aye.
Abler votes aye. Senator Jasinski.
Senator Weber votes aye.
Weber votes aye. Senator Jasinski.
Senator Newman votes aye.
Newman votes aye. Senator Jasinski.
Senator Ingebrigtsen votes aye.
Ingebrigtsen votes aye. Senator Jasinski.
Thank you, Mr. President. Senator Chamberlain votes aye.
Chamberlain votes aye. Senator Friends.
Thank you, Mr. President. Senator Carlson votes no.
Carlson votes no. Senator Friends.
Senator Champion votes no.
Champion votes no. Senator Friends.
Senator Eaton votes no.
Eaton votes no. Senator Friends.
Senator Eakin votes aye.
Eakin votes aye. Senator Friends.
Senator Fateh votes no.
Fateh votes no. Senator Friends.
Senator Isaacson votes no.
Isaacson votes no. Senator Friends.
Senator Latz votes no.
Latz votes no. Senator Friends.
Senator Newton votes no.
Newton votes no. Senator Friends.
Senator Rest votes aye.
Rest votes aye. Senator Friends.
Senator Torres Ray votes no.
Torres Ray votes no. Senator Friends.
And Senator Bigham votes no.
McEwen.
No, Senator
Sorry.
Bigham.
Bigham votes no. Okay. All members having voted who have the desire to vote, the Secretary will close the roll. There being 39 ayes and 27 nays, the bill is passed and its title agreed to. Next, we'll move to the 13th order of business, announcements of Senate interest. Without objection, the following members will be excused from today's session. Senator Bigham from 1 p.m. to 1:45 p.m. and Senator Nelson from 1:20 to the end of session. Announcements of Senate interest. Senator Herr.
Mr. President, thank you. On May 14th is the day that our state put into law in 2019 as Hmong Special Guerrilla Units Remembrance Day to honor and commemorate yearly their service and sacrifice of the SGU veterans and their allies for the Secret War in Laos from 1960 to 1975, and remember those who also died due to government persecution as a result of U.S. involvement. A gathering will be held at the Secret War Memorial at our Capitol Mall at 3 o'clock, going to 4:30, and I encourage the Senate members to attend. Should you plan to be there, I will be speaking, so do let me know so I can give you proper acknowledgement. And thank you, Mr. President, for allowing me to make this announcement. I also like to ask members to stick around at the end of the session for another announcement. Thank you, Mr. President.
Further announcements of Senate interest. Senator Rosen, followed by Senator Kent. Senator Rosen.
Thank you, Mr. President. The Senate Finance Committee will convene 15 minutes after the end of session. It is a Zoom only.
Announcements of Senate interest. Senator Kent.
Thank you, Mr. President. Will Senator Gazelka yield for a question?
Senator Gazelka will yield. Senator Kent.
Thank you, Mr. President. Senator Gazelka, here it is Friday before the last Monday of session, and I'm just wondering if you would please share with us what your expectations are for the next couple of days.
Senator Gazelka.
Mr. President, Senator Kent, members, it's always the desire of, I would say, both sides, both bodies and the governor to try to get done on time. I will tell you this is far more complex with the federal stimulus money that came in, and then guidance didn't come in right away, and some strong positions that people have on both sides. And so we're working through that. We gave the governor and the House an offer this morning. We're waiting for another offer back. I know the governor has the governor's fishing opener, which I think is important for him to do as something for the state. So that will take some time in there, and then after that, I believe we'll be resuming. So I'm hoping we get another offer back before they go. But we are really trying to get the targets, whether we get done on time Monday or not. I think it is the will of both the Speaker and myself that the committee process work the way it's intended. So if we can get that done, then we can pick a date in the future. I personally would like the governor to give up emergency powers with the most recent CDC announcement. We're going to talk about that. If he refuses to do that, we must come back June 14th, so that would be a key date. But hang in there. I can't say that I am now confident that we will get done Monday late, but we will get done.
Mr. President.
Senator Kent.
Thank you, Mr. President. And Senator Gazelka, thank you for that. It's helpful for everyone, I think, to hear it, what we're looking at this stage. It is disappointing, as others have pointed out. A number of conference committees could have met today, continued to try to make progress. There are a number of committees that have not even adopted the same and similar provisions, which we all know have already been agreed on. And, you know, we could be making progress. There are things we could be getting done, and I believe, and I agree with you. I understand the challenges with the federal funds and the unique situation that we are in this session, but that should not give us any excuse to let up on our sense of urgency to meet the needs that Minnesotans really want us to be focused on. And, you know, as we sit here today, we took up these bills, but, you know, my colleague Senator Franzen made the point that it feels like we're kind of warm in seats here today, and I think we could be doing much more meaningful and important work, and I hope our members and our conference committees will not take their foot off the gas. Thank you.
Members, any further announcements of Senate interest? Senator Benson.
Mr. President, the Health and Human Services Conference Committee will meet at 2:15.
And we do have members, just stick around. We have some guests here that Senator Pratt wants to introduce, and Senator Herr has a few words after adjournment. Any further announcements of Senate interest before we go to Senator Gazelka for his motion to adjourn? Senator Gazelka.
Thank you, members. Just a quick for the rest of where we're at. We won't meet again till Saturday at 7:30 p.m. To process anything that might be developing, and then we'll come back Monday, probably noon, and we'll know a lot more then, whether we have the targets or not, whether there's been movement over the weekend. It is my hope that we do that. As I mentioned, there's some pretty big obstacles in the way that we are getting through. And so I'm optimistic that we can figure out a way through that. I also want to make a comment, too. When I first became leader 5 years ago, I shared a personal scripture verse from Micah 6:8 for me, to do good, to love mercy, and to walk humbly before God. And I appreciate the use of scriptures. I think, frankly, they are very special to many people, for me in particular, the New Testament, but they're special for many, many people. But I just want to encourage people that, as I look at it and as I see it, it's really for our own personal reflection, not so much to beat somebody over the head to try to get them to do a different direction. And I just want to encourage people, think about that. I think everyone in this room, think about that, because it's they're priceless to many of us. They're very, very valuable, but really, I think mostly for introspection. So, members, with that, I move that the Senate do now adjourn until Saturday, May 15th at 7:30 p.m.
And Senator Gazelka, just so the body is clear, the intention tomorrow is not to take any action other than just to process paperwork. Is that correct?
Mr. President, that is correct.
Senator Gazelka moves that the Senate do now adjourn until Saturday, May 15th, 2021 at 7:30 p.m. All those in favor say aye. Opposed say no. Motion prevails. The Senate is adjourned. Senator Herr.
Thank you, Mr. President and Senate members. Our state lost a good, kind leader. Our region board member, Gauli Eileen Herr, passed away yesterday, May 13, in St. Paul. Dr. Eileen Herr was a daughter of B. Yang and Chad Herr. She was a beloved member of the Minnesota Hmong community, a committed activist for Asian Americans, and the first Hmong woman admitted to the Minnesota Bar Association. Dr. Eileen Herr was born in 1969, and due to her family involvement with the Allies U.S. Special Forces in the Secret War in Laos, her family fled Southeast Asia in October 1976 to Clinton, Iowa through the sponsorship of Zion Lutheran Church. In 1986, Eileen and her family moved to St. Paul. She graduated from Hamline University with her Bachelor of Arts degree in Political Science. 3 years later, she received her Juris Doctor degree from University of Minnesota Law School. For 15 years, Eileen served as Executive Director of the Council for Asian Pacific Minnesotans. In the recent years, she led the Hmong Elder Center. I have seen Dr. Eileen Her as a trailblazer, a leader who fought for equity and gender equality, and a superb role model for all of us, especially the Hmong American community. In 2019, Eileen was the first Hmong American to be elected to a 6-year term by the Minnesota legislature to serve as a regent of the University of Minnesota. Like all Minnesotans, she loved gardening, spending time outdoors, and being with her family and friends. I share her family grieves for Dr. Eileen, who was a member of my extended family. She was a gifted, kind, and optimistic person and a beloved sister, a public servant and a philanthropist to the very end. Dr. Eileen Her memorial service will be held on June 5th and 6th, and I will give you all more details for those who are interested in attend. On a personal note, Dr. Eileen Her and her family care so much about me in my service here for the people. They express love, thoughts, and prayers for all of us here every time. Therefore, the highest honor that I can give the family in this time of grief is to ask members of the Senate for a moment of silence here on the Senate floor. Thank you, Mr. President.
Members, please stand for a moment of silence in memory of Dr. Her. Thank you, members. Senator Pratt.
Thank you, Mr. President. Members, as many of us know, one of the privileges of being in this chamber is the ability and the opportunity to meet some very important people from other nations. And it is truly an honor to be able to welcome to Minnesota and to the Senate chamber today the Royal Thai Consulate General Pisanu Sobhan and his Deputy Consular Siraporn. They are here for the Thai New Year and have decided to stop by our capital to see us. Fortunately, we got to show them in action today. And so, members, I'd like to extend a welcome to the Consular General and the Deputy Consular General. Thank you.
All right, members, our business for the day is complete.